grounded in political inference and suspicion rather than in objective evidence capable of satisfying the test authoritatively prescribed in the Rai, Rawal, and Tunoi decisions.
The other main issue relates to public participation. In dealing with this topic, we address ourselves to three distinct but interrelated questions. First, whether the public participation exercise conducted by the National Assembly met the constitutional threshold required under Articles 10 and 118 of the Constitution. Second, whether the Senate, upon receipt of the impeachment motion, was itself obligated to carry out a public participation exercise before voting on the impeachment. And third, whether the public participation was required at the point of nomination and appointment of His Excellency Kindiki as Deputy President. The petitioners collectively contended that public participation in the impeachment process was constitutionally deficient, inadequate, and in certain stages wholly absent, rendering the entire process null and void. Their challenge was mounted at the three levels, and the petitioner advanced, they attacked the National Assembly's public participation exercise as being deficient, both in substance and procedure. They argued that the public was given less than 48 hours to digest complex charges, that the template used reduced the participation to binary support or not support choice, that His Excellency Gachagua's own response was withheld, depriving citizens of balanced information, that many venues were inaccessible, changed without notice, or restricted to party members. They also pointed to defiance of conservatory orders requiring constituency-level hearings, vagueness of the same-day notice of the 5th October 2024, anomalies in the participation report, such as a report support rate exceeding 100%, and tabling of that report moments before the debate. They also concluded that the scale of participation of about 200,000 citizens out of a population of 52 million was negligible and incapable of meeting the constitutional standards. With respect to the Senate, they contended that Senate conducted no public participation at all, no notices were issued, no hearings convened, no submissions received. They emphasized Senate's role was determinative and quasi-judicial, and therefore attracted an independent obligation to facilitate public participation. They argued that this obligation could not be discharged vicariously through the National Assembly, and that by proceeding without its own engagement, the Senate compounded the defects of the Assembly's process and arrogated sovereign power that the Constitution requires to be exercised by the people. Finally, they challenged the approval of H.E. Kindiki as Deputy President and argued that no public participation preceded the vote, yet that approval constitutes what is known as other business under Article 118, 1B, which requires public involvement. They highlighted the compressed timelines in the Senate impeachment vote on the 17th of October, the nomination of His Excellency Kindiki the same night, and approval by the National Assembly the following morning as evidence that the process was concluded overnight without public input. They distinguished this midterm vacancy scenario from a general election, noting that in elections, the people exercise sovereignty directly through the ballot, whereas in midterm appointments, public participation is the only available mechanism for engaging the people's will, and on that basis prayed for declaration that the nomination, approval, and appointment of His Excellency Kindiki were unconstitutional. The respondents, quite in summary, maintained that the National Assembly's public participation exercise was adequate, it was reasonable, and fully compliant with the constitutional requirements. They argued that notices were disseminated through the Gazette, through newspapers, through Parliament website and social media, and that multiple channels of participation were available. They defended the 2 to 3 day notice period as reasonable given the strict timelines under Article 145. They further justified the tick box template as a deliberate design to structure responses and prevent manipulation, noting that citizens could still submit their memoranda or oral views. They argued that participation by over 223,000 citizens was characterized as unprecedented civic engagement, and they dismissed the isolated His Excellency Gachagua's report with response with the public, since the public's role was to express views, not to adjudicate. On the Senate stage, the respondents in summary, contended that the public participation was not required as the Senate seats as a quasi-judicial capacity during impeachment and not as a legislature. That Article 118 applied only to legislative business and not impeachment. That impeachment was a single continuous exercise with the public participation required only at the initiation stage. Regarding the nomination and approval of His Excellency Kindiki, they submitted that public participation was not required, that Article 149(1) established a unique self-executing process where the National Assembly voted as an electoral college exercising delegated sovereignty rather than conducting legislative business, that the Constitution's silence on participation in this context was very deliberate, and that elected MPs themselves embody public representation, that the debate was open, televised, and recorded, and they concluded that the nomination, approval, and appointment of His Excellency Kindiki were fully compliant with the Constitution. We have considered the cases advanced by both parties and take the following position on this issue. It is common ground among the parties, and this court affirms that public participation is not merely a procedural formality, but a foundational constitutional value, one deeply woven into the democratic fabric of this nation. It is an expression of the sovereign will of the people, who, by virtue of Article 1, Subarticle 1 of the Constitution, are the ultimate repository of all sovereign power. That sovereignty, though delegated to state organs under Article 1(3), is not thereby surrendered. It is retained by the people and continuously exercised through, amongst other mechanisms, active and meaningful participation in the process of governance. Public participation is therefore not a gift of the state to the citizen, but a constitutional right that the state is obligated to facilitate, to protect, and to give full effect to. Under Article 10(2)(a) of the Constitution, public participation is expressly enumerated as one of the national that the national values and principles of governance bind all persons, state organs, state officers, and public officers whenever they make or implement public policy decisions, apply or interpret the Constitution or any law. The imperative of public participation finds further and specific expression in the context of Parliament in Article 118 of the Constitution, which reads as follows: Parliament shall conduct its business in an open manner, and its sittings and those of its committees shall be open to the public, and b, facilitate public participation and involvement in the legislative and other business of Parliament and its committees. At its core, public participation refers to an active process of interaction and engagement among various stakeholders who have an interest in or are affected by a particular decision or course of action. The word active is of constitutional significance. It signals that the Constitution does not contemplate a passive, cosmetic, or performative exercise in which the exercise is merely notified of a decision, in which the public is merely notified of a decision already made. It demands instead a genuine and substantive process which the people are afforded a real and meaningful opportunity to shape the decisions that affect their lives. In essence, public participation is the mechanism through which the governed speak to those who govern and through which the exercise of public power is continuously tethered to the will, values, and interests of the sovereign people. The robust jurisprudence on this subject in Kenya supports this position. The Supreme Court, in the matter of National Land Commission, this is an advisory opinion application number 2 of 2014, placed the principle of public participation at the very core of the concept of checks and balances in governance, recognizing it as integral to the manner in which various arms of government discharge their constitutional functions. Subsequently, in the British American Tobacco Kenya PLC versus Cabinet Secretary for Ministry of Health, commonly referred to as the BAT case, the Supreme Court delimited the following binding framework for public participation. The principles are that, as a constitutional principle under Article 10.2 of the Constitution, public participation applies to all aspects of governance, that the public officer and or entity charged with the performance of a particular duty bears the honors of ensuring and facilitating public participation, that the lack of a prescribed legal framework for public participation is no excuse for not conducting public participation, and the onus is on the public entity to give effect to this constitutional principle using reasonable means. That public participation must be real and not illusory. It is not a cosmetic or a public relations act. It is not a mere formality to be undertaken as a matter of course just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. That public participation is not an abstract notion, it must be purposeful and meaningful. That public participation must be accompanied by reasonable notice and reasonable opportunity. Reasonableness will be determined on a case-to-case basis. That public participation is not necessarily a process consisting of oral hearings. Written submissions can also be made. The fact that someone was not heard is not enough to annul the process. That allegations of lack of public participation does not automatically vitiate the process. The allegations must be considered within the peculiar circumstance of each case, including the mode, the degree, the scope, the extent of public participation is to be determined on a case-to-case basis. Additionally, in Cabinet Secretary for National Treasury and Planning and 4 others versus Okiya Mtata, the Supreme Court held that the constitutional threshold for public participation is one of reasonableness, that the process must afford the public a genuine and meaningful opportunity to be heard, and that Parliament must take reasonable measures to ensure the proposal, views, and suggestions received. The court spoke as follows. In the BAT case, this court established the standard that duty bearers must meet and the threshold courts should use to determine whether duty bearers have fulfilled their obligations with respect to public participation. This threshold is set at a reasonableness standard. In its guiding principles on public participation, this court defined this threshold as follows: that public participation must be accompanied by reasonable notice and reasonable opportunity. reasonableness will be determined on a case-to-case basis, close of quote. This and the broader corpus of jurisprudence firmly established that when the Constitution, the Constitution demands rather, is not necessarily the most intensive form of participation in every case, but always a form that is meaningful, purposeful, and proportionate to the nature and gravity of the decision being made. This principle finds its clearest expression in the decision of the Constitutional Court of South Africa in Doctors for Life International versus the Speaker of National Assembly and others, where the court held that the degree and nature of participation must be calibrated to the subject matter and the potential impact of the decision on affected persons. The proposition has been consistently adopted by our courts in Mui Call Basin Local Community and 15 others versus the Permanent Secretary, Ministry of Energy. The Court of Appeal affirmed that decisions of greater consequence demand more robust and substantive engagement, and that public participation ought to be meaningful rather than a tick box exercise. The High Court reinforced this position in Robert Gachagua versus Governor Kiambu County and Institute for Social Accountability versus the National Assembly, where it held that the standard of participation required is directly informed by the gravity and reach of the decision in question. We believe that it is within this rich conceptual context that the courts must approach questions about the adequacy of public participation in any given case, whether arising from the legislative process or from any other exercise of public power in which the Constitution demands the people's involvement. The focus ought to be on whether the participation that occurred was real, substantive, and meaningful. As we now turn to apply these principles to the specific facts of this matter, we do so bearing in mind that the constitutional standard is not one of perfection, but equally, it is not one of mere tokenism. The standard is meaningful participation, and that standard must be assessed with rigor, sensitivity to context, and fidelity to the constitutional vision of a government that is truly of, by, and for the people. Certainly, the impeachment of a deputy president is not an ordinary legislative act. It is amongst the most consequential, solemn, and irreversible decisions that any parliament can make. It involves the removal from office of a person who holds the second highest constitutional office in the republic, and an office to which the holder was elected by the sovereign will of the people through a general election. The gravity of that decision cannot be overstated. It affects not only the individual whose tenure is at stake, but the constitutional architecture of the executive, the stability of government, and the democratic expectations of millions of citizens who cast their vote in the 2022 general election. It is precisely because of this gravity that the public participation required in connection with an impeachment process must be held to a standard that is both qualitatively and quantitatively meaningful. It is equally against this exacting standard that we assess the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua. On the question of notice, the National Assembly adduced evidence that notices of the public participation exercise were published in multiple newspapers of wide national circulation, including the Daily Nation, the Standard, the Star, and Taifa Leo on the 2nd, the 3rd, the 4th, and the 5th of October 2024. We recognize that the publication of the notices in both English and Kiswahili was a deliberate effort to reach citizens across the linguistic divide and to ensure that the exercise was not confined to the English-speaking, urban, and formally educated segment of the population. Notice was additionally published in the Parliament's official website and on social media platform, therefore extending the reach of the process to citizens who access information through digital means. On the question of accessibility and channels of engagement, a public views template was provided in both English and Kiswahili, further reinforcing the inclusive character of the exercise. Constituency offices and county women representative offices, altogether totaling 337 access points spread across every corner of the country, were directed to remain open, including on the 5th of October 2024, to receive public submissions. Citizens were further afforded the option of submitting their views by email, by post, hand delivery, and online submissions could be made through Parliament's website, which further meant that participation was not contingent on physical presence or geographic proximity to a hearing venue. On the question of numbers, the evidence shows that just over 223,000 members of the public participated in the exercise. We are mindful that the significance of a participation number cannot be assessed in a vacuum. It must be considered in the context of the time available, the channels provided, the nature of the decision being made, and the standards previously endorsed by the courts. The Supreme Court in the BAT case affirmed that both quantitative and qualitative components are relevant to such an assessment. Equally, in Robert Gachagua, the Court of Appeal affirmed the principle that the quantitative component of public participation is a relevant but not determinative consideration, and that the adequacy of participation must be assessed in light of all the circumstances. Viewed against these standards, a participation figure of 223 citizens achieved within the constrained timeline represents a considerable level of civic engagement in a single parliamentary process. We say so further considering the relationship between the state's obligation to facilitate public participation and the public's exercise of the right to participate. These are two distinct constitutional responsibilities, and the law does not conflate them. The constitutional obligation that falls upon Parliament and upon all state organs charged with facilitating public participation is an obligation of facilitation, not an obligation of outcome. Parliament is constitutionally required to provide adequate notice, accessible channels, sufficient information, and a genuine opportunity for the public to engage. That obligation, once discharged, exhausts the constitutional duty of the facilitating organ. At least that is our understanding of the Supreme Court's pronouncement in Cabinet Secretary for National Treasury and Planning that, I quote, based on the textual markers herein, Parliament's duty is to facilitate public participation and involvement in the legislative and other business of Parliament and its committees. As is plain from its wording, this provision only imposes a duty to facilitate public participation and involvement in the legislative process, end of quote. We hold the view that what the public chooses to do with the opportunity is a matter of individual and collective civic agency, and that agency belongs to the people and not to Parliament. To hold Parliament responsible for the volume of public participation and to judge the constitutional adequacy of a public participation exercise by the number of citizens who choose to avail themselves of it would be to conflate the duty to provide an opportunity with the duty to compel its uptake. We take the position that a process that was accessible to all but availed by a few is not, by reason of low turnout alone, constitutionally deficient, provided that the low turnout was not the product of inadequate notice, inaccessible venues, suppression of participation, or any other failure on the facilitating organ. This principle finds support in comparative jurisprudence. The Constitutional Court of South Africa in Doctors for Life International case was emphatic that Parliament bears a duty to facilitate public participation and that the standard against which that duty is measured is one of reasonable facilitation. It therefore follows that the adequacy of the exercise ought not to be measured by the number of members of the public who ultimately chose to engage or by whether any particular outcome was achieved. The true measure is whether the state discharged its obligation to create conditions in which meaningful participation was genuinely possible. We are therefore persuaded that the appropriate legal standard against which compliance by the National Assembly must be measured is not one of perfection, but one of reasonable sufficiency in the circumstances. As we have stated, the Constitution does not demand flawless execution of public participation. What it demands is a genuine, accessible, and meaningful opportunity for the public to be heard. Even accepting, as we do, that logistical and operational challenges may have arisen in certain isolated cases, which is not an uncommon occurrence in any large-scale nationally coordinated exercise conducted under time pressure. Such localized deficiencies would not invalidate the entire process, as guided by the Supreme Court in the BAT decision. The evidence before this court shows that the door was opened widely, accessibly, and in good faith. Additionally, the fact that His Excellency Gachagua's response to the charges was not availed to the public during the window does not, without more, render the exercise deficient. The purpose of public participation in the impeachment process is substantively and functionally distinct from the adversarial hearing to which the respondent is entitled. The public was called upon to express its views on whether the allegations assessed on their face were of sufficient gravity to warrant a removal of a constitutional office holder. It was not and was never intended to be a mini trial of the charges. The Constitution vests the final decision-making authority in the National Assembly and the Senate, both of which are representative bodies exercising a delegated mandate from the people. These institutions heard, considered, and weighed both the allegations and His Excellency Gachagua's full response before proceeding to vote. On the question of compliance with the court orders of 3rd October 2024, which directed the National Assembly to organize public participation at least at constituency level, we find upon careful evaluation of the evidence placed before us that the National Assembly took demonstrable and timely steps to give effect to those directions. A memo from the Clerk of the National Assembly contained at page 996 of the National Assembly's document provided as follows. The title of the memo was Collection of Public Views on the Special Motion for Removal from Office by Impeachment of the Deputy President of the Republic of Kenya. And the Clerk of the National Assembly writes, as you are aware, the National Assembly is currently considering a special motion for the proposed removal from office by impeachment of His Excellency Rigathigachagua, the Deputy President of the Republic of Kenya. To facilitate this process, public hearings were scheduled to be held in all 290 constituencies on Friday, October the 4th, 2024 from 8 to 5 p.m. and members of the public were notified to submit their views to the constituency or county. Offices of all members of Parliament of the National Assembly notified to submit their views to the constituency or county offices of all members of the of Parliament of the National Assembly. By a court order issued on the 3rd of October 2024, the High Court in Kenya sitting at Kerugoya directed that the National Assembly organize similar public hearings closer to the citizens, at least at constituency level, on each constituency in Kenya to enable the constituents of members of parliament responsible for the impeachment process nationally to engage with and participate on hearings and or any other suitable modes by which citizens at that level can participate and offer their representations. In this regard, you are required to continue facilitating and coordinating the public participation exercise on the special motion within your constituency or county office. Please ensure that you implement the following: availability of forms. Ensure that copies of the public views template are physically available in your offices. In addition to the physical forms availed earlier, additional forms can be downloaded from the Parliament's website. 2. Collection of views. Collate all views, including memoranda, completed public views template, and any other submissions relating to the exercise. Note to transcribe oral submissions into written form using the designated template. 3. Submission of collected views. You are required to submit the collated views arranged per constituency to the collection center, which has been set up in Parliament Building, Nairobi, at the entrance of Bunge Tower. Alternatively, you may hand over the forms to the respective officers designated for your counties or constituencies as per the attached list. All submissions must be received by Sunday, the 6th of October, 2024. Please ensure that your respective offices remain open on Saturday, the 5th of October 2024, as from 8 a.m. to 5 p.m. to facilitate the exercise. Please utilize the operation facilities and resources available in your offices to print or photocopy the forms and to support any other aspects of this exercise. For seamless coordination, we have shared the contacts of parliamentary officers responsible for each county or constituency. I close the quote. The petitioners allege that no actual hearings were held at the constituency level, contending in effect that the exercise was a procedural facade. The allegation was effectively countered by substantial evidence presented by the National Assembly. This included the report of public participation on the proposed removal from office by impeachment of His Excellency Rigathigachagua, EGH, the Deputy President of the Republic of Kenya. The report contained a detailed analysis of the aggregated constituency tallies. See table number 4 at page 180 of the report. Supported by photographic documentation of the exercise conducted across multiple constituencies, as well as an official account comprehensively outlining the scope and substance of the proceedings. It is a well-settled evidentiary principle that a bare denial or unsubstantiated allegation cannot displace positive and particularized evidence to the contrary. The petitioners bore the burden of proving on a balance of probabilities that the public participation was an illusory or ineffective exercise. That burden was not discharged. It was also common ground that the public participation was tabled before the National Assembly on the 8th of October 2024. Members of Parliament had the opportunity to consider it before and during the debate. One of the petitioners mounted a specific and pointed challenge to the integrity of the report's data, contending that the figures recorded for Keyo South were statistically impossible in that they purportedly reflected a support rate of 162.78%, a figure that, if accurate, would self-evidently exceed the mathematical ceiling of 100% and thus portray either gross error or deliberate manipulation. we have subjected the report to careful scrutiny. Our analysis shows that in Keyo South, of the 820 responses recorded, 807 supported the impeachment, 12 opposed it, and 1 selected other. This translates to 98.41% in favor, 1.46% against, and 0.12% categorized as other. These figures, in our view, are mathematically sound and fall within the permissible range of 0 to 100% and disclose no statistical anomaly of the kind alleged. The petitioner's contention, presented as a statement of fact, is therefore not borne out by the document itself. We further find that even if isolated errors were present in data entry, tabulation, or transcription, if those errors were demonstrated to exist within a report of this scale, such minimal errors would not without more vitiate to the entirety the otherwise lawful and substantially compliant public participation exercise. Therefore, having wholly examined the totality of the evidence produced before us, and having applied the constitutional and jurisprudential standards authoritatively laid down on the nature and quality of public participation required, we are satisfied and hereby find that the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua as Deputy President met the requisite constitutional threshold in all material respects. With regards to the Senate not conducting its own public participation, the petitioners contended that the Senate acted in violation of Article 118 of the Constitution by failing to conduct its own independent public participation exercise prior to deliberating on the impeachment of His Excellency Gachagua. This argument, while not without surface appeal, cannot be sustained upon a careful and purposeful reading of the constitutional architecture governing impeachment proceedings, and we reject it for the following reasons. The starting point is a principle of constitutional specificity. Where the Constitution makes express and particular provision for a specific process, that specific provision governs, and general provisions must yield to it to the extent of any inconsistency or tension. Article 145 of the Constitution prescribes with particularity the role and function of each House of Parliament in the impeachment process. Under that provision, the Senate's designated function is to hear the charges preferred against the Deputy President, to receive and evaluate evidence in respect of those charges, and to decide on whether the Deputy President should cease to hold office. This is, by its very nature, an adjudicative function, and one that is quasi-judicial in character, akin to the conduct of a tribunal. It is not a legislative or policy-making function. The Senate, at this stage of the process, sits not as a law-making body, but as a constitutional adjudicator, and the procedural obligations that attend to that role are correspondingly different. Article 118, by contrast, imposes obligations on Parliament in the conduct of its legislative and other business. It provides in material part that Parliament shall conduct its business in an open manner, that its sittings and those of its committees shall be open to the public, and that Parliament shall facilitate public participation and involvement in its legislative and other business. The operative phrase is legislative and other business, and the interpretive question is whether Senate's adjudicative role in impeachment proceedings falls within the scope of that phrase. We find that it does not. The phrase other business must, on a proper application of the Eusdom Generis canon of construction, be read as business of a similar nature to legislative business, that is, business involving the formulation, review, review or consideration of policy or law. We respectively associate ourselves with and adopt as correct the position taken by this court in Mwangaza versus County Assembly of Meru that public participation in impeachment proceedings primarily occurs at the county assembly level rather than at the Senate level, since the county assembly is the initiating body that formulates and debates the impeachment motion before transmitting it to the Senate for final determination. End of the quote. At the Senate stage, the function being discharged, as we have said, is adjudicative rather than consultative. We find that the constitutional principle underlying that holding is not confined to the impeachment of governors. It is a principle of general application that derives its force from the structural logic of the impeachment framework embedded in the Constitution, and it applies with equal force and validity to the impeachment of the Deputy President under Article 145. A second invocation of the same procedure in respect of the same charges, the same allegations, and the same subject matter at the Senate level serves no additional constitutional purpose. We therefore find that the Senate did not violate Article 10 or 118 by failing to conduct its own independent public participation. Finally, the question of whether public participation was constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President calls for a holistic interpretation of Article 149(1) of the Constitution, read in its proper textual, structural, and purposive context. Article 149(1) provides in express and unambiguous terms that within 14 days after a vacancy in the office of Deputy President, the President shall nominate a person to fill that vacancy, and that the National Assembly shall vote on the nomination within 60 days of receiving it. The correct approach to that interpretive exercise is well settled. The Supreme Court affirmed in the matter of the principle of gender representation in the National Assembly and Senate that constitutional interpretation must be holistic and that no provision of the Constitution may be read in isolation, divorced from the broader architecture of the document of which it forms part. The court elaborated the context of that holistic approach in the matter of Kenya National Commission on Human Rights, holding that holistic interpretation requires contextual analysis, which is reading a constitutional provision alongside and against related provisions so as to arrive at a rational and principled understanding of what the Constitution must be taken to mean, having regard to its history, the issues in dispute, and prevailing circumstances. It is this disciplined, context-sensitive methodology that we apply to the question at hand. A holistic reading of Article 149(1) in its contextual context reveals compellingly that this provision is self-executing. It prescribes a complete and self-contained procedure of nomination by the President within 14 days, followed by a vote by the National Assembly within 60 days. It makes no cross-reference to any other article for supplementary procedure. Critically, it makes no mention of public participation, nor of committee vetting, nor of any other consultative mechanism. The framers of the Constitution were not silent on public participation by inadvertence. When they intended to require it, they said so in express terms. Article 118(1)(b) expressly mandates Parliament to facilitate public participation in its legislative and other business. the deliberate omission of any equivalent requirement from Article 149(1) is itself a constitutional signal that must be given interpretive effect. To read a public participation requirement into Article 149(1), where none appears in the text, would be to engage in precisely the kind of unbridled extrapolation that the Supreme Court cautioned against in Kenya National Commission on Human Rights. The constitutional text of 149(1) is further instructive in its precise choice of language. The provision directs that the National Assembly shall, and in quotes, vote on the nomination. This is a deliberate linguistic choice by the constitutional drafters, and it is not open to a court to substitute its own preferred terminology for that which the Constitution has expressly employed. As the Speaker of the National Assembly correctly ruled, the phrase vote on connotes an electoral determination, so that the National Assembly was in constitutional substance electing the Deputy President from among the nominee presented by the President, and not approving an executive appointee in the manner of a parliamentary vetting process. That interpretation is faithful to the constitutional text and is consistent with the structural design of that provision. This understanding is further reinforced by Articles 1, 2, and 1, 3 of the Constitution, which vest sovereign power in the people and provide for its delegation to, among other organs, Parliament. When the National Assembly votes on a nominee for Deputy President under Article 149(1), it is not acting as a conduit for public opinion, but exercising delegated sovereign authority on behalf of the people. The Constitution makes a deliberate structural choice not to provide for a by-election to fill a mid-term vacancy in the office of the Deputy President, electing instead to vest that determination in the National Assembly as the people's primary representative institution. That choice reflects a conscious constitutional calibration of the respective roles of participatory and representative democracy, a calibration that this court is bound to respect. To accept the petitioner's contention that public participation is a constitutional prerequisite for every decision of constitutional importance would be to obliterate the distinction between participatory and representative democracy, and to impose an obligation on the National Assembly to conduct public participation before every significant vote, including the election of the Speaker, the Deputy Speaker, and appointment of committee chairs. That is plainly not what the Constitution requires. As this court confirmed in Okoiti and 6 others versus Cabinet Secretary for National Treasury and Planning, where it was held that the representative democracy as a complement to participatory democracy is independently and fully constitutionally recognized. The Supreme Court stated as follows, that Article 1(1) declares that the sovereign power belongs to the people of Kenya, and that power can be exercised only in accordance with the Constitution. Article 1(2) further proclaims that the people may exercise their sovereign power either directly or indirectly through their democratically elected representatives. It is this direct democracy aspect the Constitution provides for citizens to participate in referenda on certain constitutional amendments as outlined in Article 255. Additionally, it promotes a participatory approach to governance with Article 10(2)(a) identifying democracy and participation of the people as national values and principles of governance. This is reinforced by specific constitutional obligations such as the duty imposed on Parliament under Article 118 1B to facilitate public participation and involvement in its legislative and other business. Conversely, the Constitution also provides for indirect democracy. In that regard, Article 1.3 states that sovereign power is delegated to specified organs, state organs, including parliament and the legislative assemblies of county governors. Moreover, Article 94(1) of the Constitution provides that the legislative authority of the Republic is derived from the people and at national level is vested in and exercised by Parliament. This speaks to the representative aspect of democracy, which grants elected representatives the discretion to make legislative decisions on behalf of the people they represent, with the legislative discretion being balanced by the Constitution's commitment to participatory governance. End of quote. While it is unquestionably correct that Articles 110 and 118 of the Constitution apply to all state organs and to all public business, it does not follow that every discrete act of Parliament is intended or is attended by a mandatory public participation obligation. The vote contemplated by Article 149(1) is a discrete, constitutionally prescribed electoral act. It is not the making of a law, it is not the formulation of a policy, it is not the implementation of a public program. It is a binary determination of acceptance or rejection of a single presidential nominee in which there is no middle ground, no policy choice to be made, no legislative text to be drafted, and no program to be designed. Public participation, the purpose of which is to inform deliberative and policy-oriented public decision-making, would add nothing of constitutional value to a binary vote of this character. Furthermore, even were one to extend the concept of public participation to encompass public observation and accountability, we do find that the proceedings of the National Assembly on the nomination of His Excellency Kindiki were conducted in a fully open and transparent manner. The debate was televised, the proceedings were recorded in Hansard, the press was free to report, and members of Parliament were directly accountable to their constituents for the manner in which they exercise their votes. We are therefore satisfied that this openness and transparency, which is a constitutional core of Article 118(1)A's requirement that public conducts its business in an open manner, was amply satisfied. For the foregoing reasons, we hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149(1). Next, I will look at the main issue on constitutionality and legality of the standing orders. The petitioners asked this court to consider and pronounce itself on the National Assembly's Standing Orders number 64(2) and 65, as well as Senate Standing Orders 75, 78, 79, and 80. Beginning with the National Assembly, some of the petitioners assailed the constitutionality of Standing Order number 64(2), contending that the provision imposed an impermissibly truncated 7-day timeline for the disposal of impeachment proceedings. They argued that such compressed timelines undermined meaningful public participation and curtailed the rights to a fair hearing guaranteed under the Constitution. They thus prayed for a declaration that Standing Order 64(2) is unconstitutional, null and void to the extent that it prescribes a timeline that is incompatible with constitutional requirements for public participation, fair hearing, and compliance with court orders, and an order of certiorari to quash Standing Order number 64 and 65 of the National Assembly Standing Orders to the extent that they apply to the Deputy President. The respondents in answer defended the constitutional validity of Standing Order 64(2) and 5, contending that they are necessary for the expeditious conduct of impeachment proceedings. They pointed to the Constitution itself as a source of the condensed timelines, including Article 145(2)(a), which requires the Speaker to notify the Senate within 2 days, Article 145(3), which requires the Senate to convene within 7 days, and Article 145(4), which requires a special committee to report within 10 days, and submitted that it would be illogical to impugn a standing order that prescribes a 7 to 12-day time frame when the Constitution itself operates within a similarly compressed time frame. The respondents further submitted that Article 124(1) expressly empowered each House of Parliament to make standing orders for the orderly conduct of its proceedings, and that Standing Order 64(2) is a legitimate and necessary operationalization of that constitutional framework. They urged the court to exercise restraint in accordance with the separation of powers on the issue. Having carefully considered the rival contentions of all the parties, we now pronounce ourselves as follows. It is trite that standing orders are subordinate legislation deriving their authority not from Parliament itself, but from the Constitution. Article 124(1) of the Constitution expressly empowers each House of Parliament to make standing orders for the orderly conduct of its proceedings, including those of its committees. Article 124(2) further entrenches the role of parliamentary committees within this framework. Being creatures of the Constitution, we agree with the submission that standing orders must at all times conform to the spirit of the Constitution, its values and animating principles. They cannot rise above the instrument that gives them life. Standing Order 64 prescribes a procedure for removal of the Deputy President under Article 145 of the Constitution. Standing Order 65(2) extends this procedure with necessary modifications to the impeachment of a Deputy President under Article 151(b) of the Constitution. Standing Order 64(1) requires that a member seeking to initiate such a motion must submit it in writing to the clerk, clearly stating the grounds of removal supported by at least 1/3 of all members. The motion must particularize the alleged gross violation of the Constitution or other written law, cite the precise provisions alleged to have been violated, and be accompanied by evidence sufficient to substantiate the allegations. The specifically impugned provision, Standing Order 64(2), by the Speaker within 3 days in accordance with Standing Order 47, and thereafter by the Assembly within 7 days of notice. Should the Assembly fail to act within that period, the motion is deemed withdrawn and may not be revived in the same session save with the leave of the Speaker. The combined effect is that once an impeachment motion is properly filed, it is subject to strict and unforgiving timelines. 3 days for the Speaker's action and 7 days for the Assembly's disposal, failing which the motion lapses in its entirety. It is these rigid timeframes that the petitioners impugned as unconstitutional. Now, the constitutional provisions engaged by the challenge are uncontested. Article 2(4) of the Constitution, which provides in terms that admit of no ambiguity that any law, including subordinate legislation that is inconsistent with the legislation with the Constitution, is void to the extent of the inconsistency, and any act or omission in contravention of the Constitution is invalid. Article 50, which guarantees the right to a fair hearing, and Article 10 and 118, which further enshrine public participation as a constitutional obligation binding on all state organs, including Parliament, in the exercise of their functions. We have examined at length the constitutional requirements and parameters that govern public participation in impeachment proceedings, and we have set out the applicable principles in detail in the preceding sections of this judgment. In determining whether the timelines in the impugned standing orders contravene these constitutional imperatives, it is not lost on us that Parliament is not a resource-constrained institution. It possesses the institutional capacity, the administrative infrastructure, and the constitutional mandate to reach every part of the Republic through its structures at both the county and national levels. If Parliament genuinely considered 7 days to be a sufficient window for public participation, it bore a corresponding constitutional obligation to deploy its resources adequately to ensure that the process was not merely open in form, but accessible in fact, and that it met the participation threshold authoritatively settled in the BAT decision. A compressed timeline, standing alone, is therefore not necessarily a constitutional infirmity. A compressed timeline, accompanied by an under-resourced and inadequately facilitated process, is an altogether different matter. Still, the question that this court is required to answer is whether 7 days encompassing the logistical demands of public notification, the organization of participatory forums across a diverse and geographically expansive republic, the receipt and meaningful consideration of public input, and the Assembly's own deliberation on a matter of this constitutional gravity is structurally adequate to meet that threshold. We draw from the Supreme Court of Canada's holding in Hyde Nation versus British Columbia Minister of Forests, a 2004 decision, that the adequacy of any participatory process must be measured against the gravity, as we have said, of the decision that is being made, and that the more consequential decision, the more robust the participation exercise must correspondently be. At the same time, we are mindful of the importance of according appropriate deference to Parliament in the regulation of its internal proceedings as required under Article 124(1) of the Constitution. In the Supreme Court decision in the Speaker of National Assembly versus the Attorney General, the Supreme Court stated that the court would be averse to questioning parliamentary procedures formulated to regulate internal workings, and the court would not do so as long as the same do not breach the Constitution. Having regard to all the foregoing, we do not consider it warranted to declare Standing Order 64-2 unconstitutional. A declaration of unconstitutionality is a remedy of last resort and a judicial act of the gravest constitutional consequence, not to be visited against upon rather a legislative provision where the provision is capable of a constitutional interpretation or application. We are further guided by the principle of constitutional avoidance that where a provision of subordinate legislation can be read and where it can be applied in conformity with the Constitution, the court ought not to strike it down when a less drastic remedy is available. This principle was affirmed by this court in IEBC versus Minor Kiai and 5 others, where it was held that interpretive generosity must extend where reason permits to the provisions whose constitutionality is challenged. We are not persuaded that the mere existence of a 7-day timeline taken in isolation and on its face renders Standing Order 64-2 void. A provision is not unconstitutional simply because it is capable of being applied unconstitutionally. The vice lies not in the number of days prescribed, but in what Parliament does or fails to do within those days. The timeline, considered as an abstract legislative proposition, is therefore not in itself the source of any constitutional infirmity. The infirmity, where it arises, lies in the manner of implementation and in whatever parliament operating within that compressed window deploys Parliament operating within that compressed window deploys adequate resources, establishes genuinely accessible structures, and puts in place meaningful mechanisms sufficient to discharge its constitutional obligations of public participation under Articles 10, 50, and 118 in substance and not merely in form. The distinction we draw is between a provision that is unconstitutional on its face and void in all its applications, regardless of how it is applied, and one that is conditionally constitutional, as in valid in law, but only where its application is accompanied by the institutional effort and constitutional seriousness that the gravity of impeachment proceedings demands. Standing Order 64-2 falls, in our judgment, in the latter category. In declining to strike down Standing Order 64-2, we instead note that the timeline prescribed in that standing order is not constitutionally mandated. Unlike certain procedural requirements that derive their specific content from express constitutional text, the 7-day window is a creature of parliamentary regulation alone. Parliament was free to prescribe a longer period and still remains free to do so. The experience of the first impeachment of a deputy president to come before the National Assembly under the Constitution of Kenya 2010 might have been a sobering constitutional experience. It may have exposed in real time the structural tensions that compressed timelines have the potential to create when applied to proceedings of national consequence. We commend to Parliament for its serious consideration in the exercise of its sovereign authority to regulate its own proceedings, the question of whether the timelines prescribed in Standing Order 64-2 remain adequate in light of this experience, and whether a timeline that builds in more time for public participation and for the Assembly to deliberate with the gravity that removal from constitutional office demands would not be more befitting of the constitutional moment that the impeachment invariably represents. As it stands, however, we find nothing unconstitutional about the standing order. With respect to the Senate standing orders, the petitioners assailed the constitutionality of Standing Order 75, 78, 79, and 80 to the extent that they apply to the Deputy President, advancing their challenge on 3 grounds. First, that Standing Order 79 was a mechanical imputation of the presidential impeachment framework to the Deputy President's distinct constitutional position without any effort to modify the required identify the required modifications as required by Article 150 to 152. Second, that the appointment of a special committee was mandatory under Article 145(3)(b), and that Standing Order 79 did not mirror this requirement. Third, that the 14-day timeline under Standing Order 75 was structurally incompatible with Articles 47, 50, and 145(5), and was grossly inadequate for proceedings involving 11 complex constitutional allegations. The respondents maintain that Article 145(3)(b) uses the word may, which confers a discretion and not a mandatory obligation, that the fact that Standing Order 80 expressly provided for a plenary alternative, while Standing Order 79 did not, was constitutionally significant, as the discretion was conferred by the Constitution itself. They further submitted that Article 152 did not require a formal or recorded exercise of identifying modifications, and that the modifications were implicit in the different constitutional status of the Deputy President. They relied on Speaker of the Senate and another versus Attorney General and another for the proposition that courts should not read into the Constitution obligations that its framers deliberately chose not to include. We have considered the submissions put forward by the parties, and for the avoidance of doubt, standing orders, we provide verbatim what the standing order 75, 78, 79, and 80 all provide. Allow me not to go through that. The principle that standing orders must conform to the Constitution applies with equal force to the Senate as it does to the National Assembly for the reasons we have already set out in the preceding section of this judgment. Our jurisdiction to examine that conformity is equally settled and will rely on the case of Orange Democratic Party versus Speaker of National Assembly and Ombogi and 9 others versus County Assembly of Nyamira. We note that Standing Order 78 largely mirrors the impeachment procedure provided for under Article 145. As such, the question of whether the special committee contemplated under standing orders is mandatory or discretionary and the constitutionality of those standing orders is in the context of Article 145(3)(b is addressed separately in the next ground. On the specific challenge to the absence of a formal recorded modification process under Article 150 sub-article 2, some petitioners argue that the phrase with necessary modification in Article 150 sub-article 2 of the Constitution is a mandatory constitutional directive requiring Parliament to enact a substantive legislative framework tailored to the distinct office of the Deputy President. They emphasize that unlike the President, the Deputy President enjoys no civil or criminal immunity under Article 143, and therefore impeachment must be treated as a mechanism of last resort. In their view, a mere transposition of the presidential framework through standing orders is inadequate and constitutionally insufficient. The respondents countered that with necessary modification is nothing more than a drafting device requiring only the mechanical substitution of president with deputy president. They maintained that the obligation was discharged through the National Assembly Standing Order 65-2 and Standing Order 79, and that the Parliament's procedural autonomy under Article 124(1) shields its internal arrangements from judicial scrutiny. We are unable to accept the respondent's construction. Taken to its logical conclusion, it renders the phrase superfluous. If the Constitution intended mere substitution, it would not have qualified the incorporation of Article 145 at all. The deliberate insertion of those words signals that the drafters anticipated substantive adaptation as opposed to a mechanical production or drafting convenience. This conclusion is reinforced by the structural asymmetry between the two offices, partly under Article 143. We do agree with the submission that a framework that ignores this distinction has not applied Article 145 with necessary modification. It has applied it without modification at all. The standing orders relied upon by the respondents do not cure this deficiency. National Assembly Standing Order 65-2 and Senate Standing Order 79 merely echo the constitutional command without discharging it. They reproduce the obligation verbatim, but provide no substantive modification at all. The county experience is instructive in this procedural questions that a comprehensive statutory framework ought to have addressed in advance. the subsequent county government's state officers' removal from office procedure bill of 2024 was Parliament's legislative acknowledgement of that inadequacy. That bill codifies due process protection, imposes timelines, mandates public participation, establishes a hierarchy between statute and standing orders, and resolves ambiguities such as the role of Senate in voting on charges regardless of committee findings. By contrast, the national framework for removal of the deputy president contains none of such safeguards. The very issues agitated in the petitions before us, including the inadequacy of public participation, the role of the special committee, procedural rights of the deputy president, timelines, and neutrality of presiding officers, are precisely the questions a dedicated legislative framework would have foreclosed. Equally, the question on judicial intervention before an impeached president or deputy president is replaced would also be addressed in the legislation. Their resolution through litigation rather than legislation, and the challenges that the impeachment proceedings have brought forth is itself evidence of that lacuna. Courts do not legislate, but it is within the proper constitutional role of the courts to identify legislative gaps and invite Parliament to address them, particularly where those gaps carry the potential for constitutional crisis. We therefore find that the existing framework under Article 150 is structurally inadequate. The absence of a comprehensive structural framework does not preserve parliamentary autonomy. It transfers the resolution of fundamental procedural questions to the courts at considerable cost to institutional certainty and public confidence. We therefore hold that Parliament ought urgently to enact a dedicated statutory framework for the removal of the Deputy President under Article 150. We do observe, however, that the absence of such legislation does not invalidate the impeachment process already undertaken. This is because the Constitution itself, at Articles 144 and 145, sets out the minimum threshold for conducting such proceedings. It is upon this constitutional framework that Parliament relied, ensuring that the process was carried out in a manner designed to safeguard the Deputy President's protections. On timelines, we note that Standing Order 78-2 imposes a 10-day timeline in respect of a special committee investigation. Neither the standing orders nor the Constitution prescribes a timeline for plenary proceedings. The Senate's adoption of a 10-day deadline for its plenary hearing was therefore a self-imposed procedural choice and not a requirement of the standing orders or the Constitution. The Senate was not obligated by any applicable rule to impose that timeline when it elected to proceed by way of plenary. And the petitioners have not demonstrated that the choice to do so was in itself a constitutional violation.
I will now deal with two issues, that is the composition of the National Assembly and IBC, and the issue of the constitutional processes. I'll start with the issue of composition of the National Assembly and the IEBC. Three other issues were raised under the heading, including whether the National Assembly was properly constituted to consider the impeachment motion, whether the nomination of His Excellency Kindiki could take place in the absence of fully constituted IEBC, and whether his nomination as Deputy President was infirm. We shall address these issues in turn. The third petitioner Honorable Jen Njeri, invited this court to declare that the National Assembly, as presently constituted, was not legally constituted for failure to comply with the constitutionally two-thirds gender principle under Articles 27, 81B, 100, and 261 of the Constitution. She submitted that, as a consequence, the National Assembly is incapable of entertaining or deliberating on the impeachment motion against the Deputy President. She therefore sought declarations impugning both the legality of the National Assembly and the validity of the proceedings arising from its resolution. The respondents opposed that contention. The National Assembly and its clerk maintained that the constitutional requirements concerning the composition of Parliament under Articles 97 and 98 of the Constitution had been satisfied. They admitted that they submitted that the two-thirds gender principle did not render Parliament unlawfully constituted or incapable of functioning, and that Article 261 itself establishes the constitutional mechanism for securing compliance where legislation or implementation has lagged. They warned that acceptance of the petitioner's proposition would invalidate all parliamentary business undertaken since 2013, an outcome they described as constitutionally untenable and absurd. The Speaker of the Senate and the Senate associated themselves with that position and further urged judicial restraint, submitting that despite that the dispute concerning implementation of the two-thirds gender principle remains actively before a duly constituted 5-judge bench in Conchela and others. There can be no controversy that the two-thirds gender principle is a constitutional imperative. Article 81B decrees that not more than two-thirds of the members of elective bodies shall be of the same gender. Article 27 and Article 100 reinforce the constitutional commitment to equality, inclusiveness, and equitable representation. The courts of this country have consistently affirmed that gender principle is not ornamental constitutional rhetoric, but a binding constitutional stance that demands implementation. Equally, however, constitutional adjudication must be undertaken within the framework of the Constitution and the dispute resolution mechanisms it establishes. The question before us is not whether the two-thirds gender principle is obligatory. It undoubtedly is. Rather, the narrower and the more immediate question is whether the alleged non-compliance with that constitutional principle rendered the National Assembly illegally constituted as to deprive it of authority to entertain and determine an impeachment motion under Articles 145 and 150 of the Constitution. Article 261 of the Constitution speaks to the timelines within which legislation ought to be passed by Parliament. It also provides for the consequences of failure to pass legislation. On such a failure, a petition may be filed in the High Court, and the court may grant a declaratory order directing Parliament and the Attorney General to take steps to ensure that the required legislation is enacted within the period specified in the order and to report the progress to the Chief Justice. In the event Parliament fails to enact the legislation in accordance with the court order, the Chief Justice shall advise the President to dissolve Parliament, and the President shall so dissolve Parliament. The new Parliament shall then enact legislation within the timelines contained in the court order, lest it faces similar consequences. The issue of failure by Parliament to enact the legislation on the gender rule has been litigated in courts for relatively long. Further, in an advisory opinion filed in the Supreme Court, other petitions under Article 261 have been filed in the High Court and declarations made. The Honorable Chief Justice, even advised the president to dissolve parliament. It was that advice that elicited the institution of Conchela and others versus Chief Justice Supra. The matter was recently determined by an expanded bench of this court via the judgment delivered on the 5th of June 2026, that is last Friday, where the advice to dissolve parliament by the Honorable Chief Justice to the president was declared unconstitutional and subsequently quashed for failure to comply with some fundamental procedural steps. The court, however, clarified that the parties were still at liberty to comply with the requisite procedural steps, and that which the law will then follow its course. Therefore, as long as the redress in Article 261 is yet to be fully realized, it will be premature for this court to declare that the National Assembly was not properly constituted to consider the impeachment motion. To that end, the contention fails. The challenge to the IBC was advanced on two related grounds. First, that IBC was constitutionally incapacitated by the absence of commissioners at the material time, such that any verification of His Excellency Kindiki's qualifications being a substantive commission-led function under Article 250, Sub-Article 1, could not lawfully be performed by the Secretariat alone. And second, that the clearance process was consequently a nullity that fatally infected the nomination. The respondents, however, maintained that the midterm replacement mechanism under Article 149, Sub-Article 1, was a sui generis self-executing constitutional process that did not engage the IBC electoral mandate under Article 88, Sub-Article 4, and that the strict eligibility and clearance protocols under Articles 99 and 137 applied exclusively to general elections and not to midterm nomination vetted directly by the National Assembly. Our reading of Article 149, Sub-Article 1 confirms that it is unambiguous, express, and self-contained. It establishes a strict executive legislative process where the president nominates and the National Assembly votes on the deputy president nominee. It makes no reference to IEBC. That omission is not an oversight. It is a deliberate constitutional choice which this court must give full effect. Were it the intention of the drafters to impose a more stringent requirement, nothing would have been easier than to say so expressly, as they did in Articles 99 and 137 in respect to candidates for elective office at a general election. The absence of any equivalent requirement in Article 149, Sub-Article 1 is therefore a considered constitutional choice to be respected. For ease of reference, Article 149, Sub-Article 1 provides as follows, and I quote, vacancy in the office of Deputy President. Within 14 days after a vacancy in the office of Deputy President arises, the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. From a plain reading of the above, we are convinced that no clearance was required by the Deputy President, and that the vote by the National Assembly was an expression of representative authority by the sovereign's elected representative, precisely the constitutional mechanism that Article 149, Sub-Article 1 contemplates. Under Article 1 of the Constitution, sovereign power belongs to the people of Kenya and may be exercised either directly or through their democratically elected representatives. When the National Assembly voted on His Excellency Kindiki's nomination, it did so as the constitutional repository of delegated sovereign authority acting on behalf of the people in accordance with the specific mechanism the Constitution provides for filling in a midterm vacancy in the office of the Deputy President. We equally accept the respondent submissions that on the deliberate use of the word vote in Article 149(1) as opposed to the words approve or vet that the Constitution employs in other contexts. That distinction is constitutionally significant. Across the Constitution, we note that the word approve is used where Parliament exercises a confirmatory function in relation to executive appointments, as in the approval under Article 132, Subarticle 2 of Cabinet Secretaries, the Attorney General, the Secretary to the Cabinet, the Principal Secretary, the High Commissioners, Ambassadors, and diplomatic consular representatives, as well as any other state or public officer whom the Constitution requires or empowers the President to appoint or dismiss. The same applies to the approval of the candidates for constitutional offices such as the Chief Justice under Article 166 of the Constitution. In those contexts, approval connotes a deliberate and structured vetting exercise in which Parliament assesses the suitability of the nominee against a prescribed criterion, and in which the IBC or other constitutional bodies may have a role to play in verifying qualifications. The word vet carries similar connotations of structured scrutiny against defined standards. The word vote, by contrast, denotes a direct and immediate exercise of collective democratic will. It is the language of elections and of sovereign determination. Its use in Article 149, Subarticle 1, signals that the National Assembly's function in the midterm replacement process is not to sit in the judgment of the nominee's suitability, but to exercise on behalf of the people a direct democratic determination on whether the president nominee should fill the vacancy. That determination is political and representative in character, and it is expressed through the ballot of elected members of Parliament, each of whom is accountable to their constituents for the vote they cast. It consequently follows that no input or intervention by the IBC was constitutionally required in the midterm replacement process under Article 149(1). The absence of any IBC involvement would not have rendered the nomination or the filling of the vacancy unconstitutional. The informational input by the IBC Secretariat did provide was, in those circumstances, entirely voluntary in character. It was not a condition precedent to the validity of the process, and its presence or absence was constitutionally irrelevant to the outcome. That being so, the fact that the input was provided by the Secretariat in the absence of commissioners is equally irrelevant if the input was not required at all. The question of whom within the IBC provided it simply does not arise. For completeness, however, and to the extent that any residual question remains about the lawfulness of the Secretariat's involvement, we are satisfied that the informational verification performed by the Secretariat could not have constituted a clearance in the electoral sense, but rather a routine administrative task, and as such not constitutional or policy-driven. The same was legally permissible and procedurally valid and fell squarely within the Secretariat's lawful administrative mandate. We draw from the advisory opinion number 4 of 2024 IBC and the Honorable AG, where the Supreme Court gave guidance on the dichotomy that exists between the role of the commissioners and that of the Secretariat in the following words. And I quote, "The Secretariat, under the leadership of the Commission, Secretary and the CEO, is empowered to undertake routine administrative and operational tasks essential for the day-to-day functioning of the Commission. In the same vein, it is necessary to clarify that the absence of commissioners does not of itself vitiate or invalidate administrative actions taken by the Secretariat within the scope of its lawful mandate, including the execution of contracts, management of personnel, procurement, and other functions necessary for institutional continuity. Such acts remain valid and binding, and provided they fall within these bounds of statutory delegation and do not purport to usurp the constitutional function of the commission as a corporate body, end of quote. To guard against institutional overreach, the Supreme Court carefully delineated where IBC's administrative mandate ends as follows, and the court, once again, having concluded as above, a clear distinction must be drawn between administrative continuity by the Secretariat and the exercise of constitutional authority vested in the Commission as a collegial entity. It is our considered view that the exercise of constitutional function expressly reserved for Commission, such as those enumerated under Article 88, Sub-Article 4 of the Constitution, cannot be lawfully discharged in the absence of a properly constituted commission with the requisite quorum as contemplated under Article 250, Sub-Article 1 and Sub-Article 2 of the Constitution, end of quote. This differentiation of responsibility is further contained in Section 11A of the Independent Electoral and Boundaries Commission Act and exposed by the Supreme Court in the Muruli versus Oparanya and 3 others case. For all these reasons, it is our finding that the Secretariat did not travel beyond its mandate. It simply functioned as an information repository. Having so found, we now move to the last sub-issue concerning the constitutional validity of His Excellency Kindiki's nomination. The petitioners anchored the ground on Article 148, Sub-Article 1, read with Article 137, contending that His Excellency Kindiki was serving as Cabinet Secretary for Internal and National Administration, a state office under Article 260, at the time of his nomination and parliamentary approval on the 18th of October 2024. He was disqualified from nomination by dint of Article 137, Sub-Article 2B, rendering the entire process null and void ab initio. In contrast, the respondents who responded to this ground argued that the appointment process was completely legal and procedurally sound. They maintained that the filling of mid-term vacancy under Article 149, Sub-Article 1 was an independent sui generis executive-led process, and that was distinct from traditional election or appointment. Further, it was the case that the restrictive disqualification in Article 137, such as the recruitment to the requirement to resign 6 months prior to or to secure multi-county voter endorsement, were tailored exclusively for general elections, not sudden midterm vacancies that demanded swift action to prevent a leadership vacuum. They contended that the initial formation of a presidential joint ticket under Article 148 could not apply to midterm emergency transitions. In addition, His Excellency Kindiki and the IBC specifically disputed the factual basis of the petitions, arguing that His Excellency Kindiki had in fact provided official gazette notices proving he had formally resigned from his cabinet position prior to his appointment as Deputy President. In considering the arguments of both parties, we turn to the relevant constitutional provisions, to wit Articles 137, 148, and 149. Article 137, Sub-Article 2B, bars any person who is a public officer or is acting in any state or other public office from nomination as a presidential candidate. Article 137, Sub-Article B, carves out exceptions for the sitting president, the deputy president, and members of parliament. Cabinet secretaries are not included in that exception. Article 148, Sub-Article 1 also locks the qualifications of a deputy president candidate to those of a presidential candidate under Article 137. And Article 148, Sub-Article 2 provides that there shall be no separate nomination process for the deputy president at a general election. Article 149, Sub-Article 1, however, creates an entirely distinct pathway of filling a mid-term vacancy, as we have already observed, through a direct presidential nomination followed by a National Assembly vote. It makes no cross-reference to the electoral machinery or disqualification timelines that apply under Articles 137 and 148 in the general election context. A strict textual reading of Article 148, Subarticle 1, and Article 137, Subarticle 2b together would, if applied without contextual qualifications, bar an active cabinet secretary from nomination unless a timely resignation had occurred. However, we are satisfied that Article 149, Subarticle 1, creates a sui generis process that cannot be evaluated by mechanical application of the general election framework. Article 149, Subarticle 1, omits the standard electoral requirements, including the signature collection requirement, and Article 137, Subarticle 1d, which signals the framers' intention that this provision operates independently of the general election machinery. To apply the strict disqualification timelines of the electoral context to a sudden or unforeseen midterm vacancy would risk creating an executive leadership vacuum of precisely the kind that Article 149, Subarticle 1 was designed to prevent. In any event, we are satisfied that the factual premise of the petitioner's challenge is not established on the evidence. The primary constitutional mischief targeted by Article 137, Subarticle 2b, is the prevention of active public servants from deploying state resources or conflicting institutional mandates to influence an election or appointment. The evidence before this court establishes that despite the unique circumstances of his nomination, His Excellency Kindiki formally resigned from the cabinet and gazetted his exit prior to taking oath of office as deputy president. By severing his ties to the cabinet before assuming the deputy presidential office, the potential conflict of interest under Article 137, Subarticle 2b is designed to address was lawfully cured. The core integrity parameters of Chapter 6 and Article 137 of the Constitution were accordingly satisfied. This ground of challenge therefore fails. Before concluding on this issue, we must address whether the speed with which the state resolution, with which the Senate resolution was gazetted, the President nominated Professor His Excellency Kindiki, and the National Assembly approved the nominee, contravened the Constitution and the law. The petitioners argued that the extraordinary haste following the Senate's resolution of 17th of October 2024 revealed a predetermined impeachment process. In their view, the immediate gazettement, swift presidential nomination, and expedited parliamentary approval were evidence of a pre-arranged outcome. They contended that such speed undermined constitutional values of transparency, accountability, public participation, fairness, and constitutionalism. The respondents, including His Excellency Kindiki, took the opposite position. They maintained that the Constitution itself anticipates expedition in matters concerning high constitutional office. Once a vacancy arose in the office of the Deputy President, they argued the President was constitutionally bound to act under Article 149. Prompt compliance with such a duty, they insisted, cannot be itself amount to constitutional impropriety. Turning to the Constitution, Article 149(1), we have already reproduced that section, that article. I don't need to go through it again. Proceed. This provision leaves no doubt that the framers of our Constitution deliberately contemplated speed in filling in a vacancy of the Deputy President's office. The rationale is evident, and it is to safeguard continuity and the stability in the national executive by requiring prompt action. Judicial President reinforces this principle. In Ali Hassan Joho and another versus Suleiman Said Shabal, and others. This is a Supreme Court petition number 10 of 2013. The court held that constitutional timelines are substantive requirements, not procedural conveniences, and cannot be extended by legislation or judicial discretion. Similarly, in the Mankin Aramat versus Harun Meitamei, Linpaka, and two others, the Supreme Court, it's a Supreme Court matter petition. The court emphasized that constitutional timelines are binding commands, cautioning against reliance on Article 159 to circumvent them. The same principle was affirmed in Moses Masika Wetangula versus Muskari Kombo, Muskari Nazi Kombo, and two others, and in Harun Meitamei Limpaka versus Limpakian Aramat, where the Court of Appeal underscored the constitutional significance of timelines. Collectively, these authorities highlight that timelines serve vital public interests, including certainty, legitimacy, and orderly governance. The Supreme Court's decision in Raila, Odinga, and 5 others versus Independent Electoral and Boundaries Commission and 3 others, this is presidential petition number 5 of 2013, is also instructive. Addressing timelines under Article 140, the court had the following to say, and I quote, according to Article 140 of the Constitution, it is clear that in the resolution of presidential election disputes, I repeat that. According to Article 140 of the Constitution, it is clear that expedition in the resolution of presidential election disputes is of essence, end of quote. The court warned that prolonged uncertainty regarding the presidency undermines public interest. This reasoning reflects a broader constitutional philosophy that uncertainty in the occupants of high office is detrimental, and the Constitution deliberately establishes mechanisms to ensure continuity. Applying these principles, we are not persuaded that the prompt gazettement of the Senate's resolution was unconstitutional. Once the Senate concluded its process, the Deputy President ceased to hold office, and nothing in the Constitution required a waiting period before gazettement. Likewise, the President cannot be faulted for acting swiftly under Article 149. He was constitutionally obligated to nominate a replacement within 14 days. Compliance with this duty cannot be construed as wrongdoing. To hold otherwise would penalize constitutional actors for fulfilling their obligations. The same reasoning applies to the National Assembly. Article 149 allows up to 60 days to vote on a nomination, but it does not require Parliament to exhaust that period. Acting sooner than the deadline is not evidence of illegality. Speed alone does not establish predetermination. The law requires objective proof that a decision maker had closed their minds before exercising power. Mere expedition does not meet that threshold. We therefore find that the gazettement of the Senate resolution, the President nomination of His Excellency Kindiki, and the nomination National Assembly's approval did not contravene the Constitution simply because they were undertaken expeditiously. I will now turn to the constitutional processes. Under this heading, this court is called upon to interpret Articles 144 and 145 of the Constitution to determine whether the Senate was obligated to establish a special committee to investigate the charges against the Deputy President, or whether the formation of such a committee was discretionary. The court is equally invited to examine the procedures applied in the impeachment process, with particular focus on Article 150, sub-Article 2, and the extent to which, if at all, the Senate ran afoul the Constitution in that respect. Starting with the first issue, the dispute before us brings into sharp focus the jurisprudential tension embedded in Article 145 of the Constitution, and more particularly, Article 145, sub-Article 3b, of the Constitution. Article 145, Subarticle 2 and Subarticle 3 detail the provision of removal in the following terms. I do not need to read those ones, those provisions, and I proceed. The true import of Clause 3B cannot be discerned in isolation. It demands a historiographical examination and a forensic appreciation of historical continuum Just a minute. Yes, I proceed. The true import of Clause 3B cannot be discerned in isolation. It demands a historiographical examination and a forensic appreciation of the historical continuum of Kenya's constitutional reform. Constitutional interpretation, particularly in matters touching on the architecture of the governance, must be informed by history, for history illuminates the intent of the framers, constitutionalizes the text, and guards against distortion that arise from reading provisions in a vacuum. As the courts have consistently held, Constitution is not merely a legal, instrument, but a living charter whose meaning is enriched by the struggles, compromises, and aspirations that birthed it. Accordingly, this inquiry necessitates tracing the evolution of impeachment clause through the Bomas draft, the Wako draft, and the harmonized draft to appreciate the context of Article 145, Subarticle 3B was ultimately incorporated into the Constitution. Article 164 of the Bomas draft outlined the procedure for impeachment, vesting the Senate with ultimate authority. It provided that upon receipt of a resolution from the National Assembly, the Speaker of the Senate would convene the Senate, and if the motion was passed, a special committee of the 13-member will be appointed to investigate the matter. The language of the Bomas draft was rigid and prescriptive. The investigatory phrase was mandatory, and the committee route was the inescapable mechanism for digesting evidentiary complexities prior to a final vote. If the committee found the allegations unsubstantiated, no further proceedings would ensue. For avoidance of doubt, it provided as follows. The Speaker of the Senate shall, if Senate is then sitting or has been summoned to bring the motion to the notice of the Senate for the consideration within 7 days, or if Senate is not then sitting, will summon it to meet within 21 days of the motion, 21 days of the notice to consider the motion. If a motion is passed under Clause 3, the Senate shall appoint 13 of its members as a special committee in accordance with its standing orders of the Senate to investigate the matter. If the special committee shall investigate the matter and shall, within 10 days, report to the Senate whether it finds the particulars of the allegations against the President to have been substantiated. End of quote. Similarly, Article 155 of the Wako draft mandated the formation of a special committee of 13 members of Parliament to investigate allegations once an impeachment motion was initiated. The provision was explicit and inflexible, leaving Parliament with no discretion. The committee route was compulsory, and the President retained the right to appear and be represented before the committee. For clarity, we have reproduced that one as well, but I will not go through it. I proceed. The harmonized draft of 2009 and its subsequent revision in 2010 represents the constitutional settlement now embodied in Article 145, which is the subject of contestation before us. To our mind, there appears to have been a deliberate harmony in the manner the previous drafts treated the committee stage of the impeachment proceedings. We are convinced that the framers intended to preserve this consistency across the drafts rather than to depart from it. This conclusion is fortified by a wholesome reading of the Constitution, which we explain in detail. Interpreting the text before us requires a careful and nuanced exercise in constitutional interpretation. Fortunately, the Constitution itself provides guidance on how it should be read. Articles 20, subarticle 4, and Articles 259, subarticle 1 establish the interpretive framework. Article 20, subarticle 4 directs courts when interpreting the Bill of Rights to promote the values of an open and democratic society founded on human dignity, equality, equity, and freedom, while giving effect to the spirit and the objects of the Bill of Rights. Article 259, subarticle 1 further commands courts to interpret the Constitution in a manner that advances its purpose, values, and principles, threatens the rule of law, protects human rights and fundamental freedoms, permits development of the law, and contributes to good governance. Over time, our courts have consistently emphasize that the 2010 Constitution demands a transformative approach to interpretation. Recognizing its highly progressive nature, courts have articulated several interpretive canons. In David D. and others, as AG, the High Court, that is the BBI case, the High Court identified 4 guiding principles: that the Constitution must be interpreted holistically, that it should not be approached with rigid formalities or treated as a mere statute, that its own theory of interpretation must be applied to safeguard its values, objects, and purpose, and that non-legal considerations are essential to uncover the true meaning and values. The Supreme Court, in the matter of Kenya National Commission on Human Rights 2014, clarified that a holistic interpretation requires contextual analysis, which means reading provisions alongside and against each other, informed by history, disputes, and prevailing circumstances. Similarly, in the Tunyefuza versus AG case, this is a Ugandan court, stressed that a constitution must be read as an integrated whole with each provision sustaining rather than undermining the others. The principle that the Constitution must not be interpreted through rigid formalism was also emphasized by the Supreme Court in Interim Independent Electoral Commission 2011 and the Communication Commission of Kenya versus Royal Media Services 2015. The court observed that constitutional interpretation requires more than positivistic approaches. The court noted that Articles 20, subarticle 4, and Articles 259, subarticle 1 incorporate non-legal considerations such as historical, social, cultural, and political realities that must inform judicial reasoning. The court highlighted that Kenya's modern Bill of Rights envisages a human-based approach and social justice-oriented society, and judicial authority derived from the people under Article 159, subarticle 1 must reflect these values in court decisions. The former Chief Justice Emeritus Mutunga, in his concurring opinion in the Speaker of the Senate and another versus the AG, this is 2013 reported, also underscored the constitution making was an ongoing process, and acknowledged that compromises in drafting often create vagueness, and it is the court's responsibility to resolve contradictions and clarify gaps. In his words, I quote, "Constitution making does not end with the promulgation. It continues with the interpretation. Finally, the Court of Appeal in Center for Rights, Education and Awareness, and another versus John Harun Mwau, 2012 reported, linked constitutional interpretation with the statutory interpretation principles. It reiterated that courts must avoid absurd, unpracticable, illogical, and artificial results and must always strive to serve the public interest. Fidelity to both the letter and the spirit of the Constitution requires interpretations that advance justice, rationality, and the common good. Guided by the interpretive principles discussed above, we now turn to examine the purpose and the intent of Article 145, Sub-Article 3 of the Constitution. We do so with full appreciation of the demands of judicial humility and the doctrine of stare decisis, which binds inferior courts